my lords, the second of my 5 main topics was the comparables cases advanced by the parties in this case. We set those out in section 2 of our appeal skeleton, which I'll come to in a moment. But it is first worth just seeing InterDigital's pleaded case as it remained throughout the trial. It's their Fran statement of case in bundle A at tab 1, page 4. And what we will see at paragraph 7 is that the pleaded case was that the terms of their offer are commensurate with industry practice and are in any event commensurate with the terms of other licenses that the claimants and other members of the IDC group have granted to undertakings similarly situated to the defendants and or the Lenovo group. And then the list was the InterDigital 20 at paragraph 8. At paragraph 9, we see the said licenses support the claimant's contention that the terms of the 5G license offer are FRAND. And paragraph 10, in particular and without prejudice to the generality of the foregoing, the said licenses support the claimant's contention that the royalty rates in the 5G extended license offer are FRAND. The claimant's primary case on the royalty rate is based on the use of those licenses as comparables. So InterDigital's only pleaded case relied on the so-called InterDigital 20 licenses with a selection of very small licensees. InterDigital had no pleaded case and never had any pleaded case based on LG 2017 or on any of the licenses which became known as the Lenovo 7. One can then see in our FRAND statement of case in bundle A at tab 2, page 49, that Lenovo pleaded reliance on a series of licenses. In fact, they start at paragraph 37.1 on page 51 with Samsung, Apple, Huawei, LG, ZTE and Xiaomi. And in InterDigital's FRAND reply at tab 3, page 91, paragraph 21, the claimants joined issue with the defendants on the utility of each of the licenses with Huawei, ZTE, LG, Apple and Samsung as comparable licenses, which utility is a matter for expert evidence. As it happens, InterDigital put in no expert or fact evidence to support the InterDigital 20. That's a point that the judge makes at paragraphs 303 to 307 of his judgment. But InterDigital's written opening nevertheless confirmed that its case at trial remained the pleaded case. This is bundle B, tab 2, at page 66. And we can see at paragraph 162 in A, of the 27 licenses in issue, InterDigital's case is based on 21 licenses granted to a wide range of participants. And then there is reference to paragraph 8 in the footnote of the FRAND statement of case. I confess, as I stand here, I can't remember why it says 21 there rather than 20, but the point remains. And then B, Lenovo's case, by contrast, is based on just 6 licenses. And they say it's with a narrower section of the industry and the such like. So it was made clear that reliance was placed by InterDigital on its pleaded case and the InterDigital 20. it's worth just seeing at paragraph 157, back at page 63, InterDigital's caution. They say it's better to look across as broad a range of comparables as possible rather than focusing on a small subset of the best. Doing so mitigates against the uncertainty inherent in any particular single comparable license skewing the analysis. So that was their case in opening. As the judge explains in paragraph 49 of his judgment, we had the fact evidence on days 3 and 4, and then Mr Brismark on day 5, and Mr Besant gave evidence on days 6 and 7. And Lenovo spent most of the first day of cross-examination of Mr Besant, day 6, on the InterDigital 20. Day 7 was the Lenovo 7. And it was only after Mr Besant had given his evidence that there was then a dramatic shift in InterDigital's case. Mr Meyer, Lenovo's valuation expert, was cross-examined on days 9 and 10. He had given a clear opinion that the InterDigital 20 were not probative comparables. That's paragraph 66 to 67 of his first report at Bundle C, tab 13, page 465. And he had indeed, if we had them in the bundle, done schedules unpacking each and every one of them. But that evidence that they were not probative comparables was left largely unchallenged. InterDigital's case on the vast bulk of the InterDigital 20, say perhaps RIM, was not even put to Mr Meyer. As the judge noted during closing argument, day 15, page 2140, line 24, we have not heard a dicky bird about the 15s, he put it. Instead, what happened, my lords, as described by the judge in paragraphs 387 to 388 and 608 of his judgment, is that InterDigital began suddenly to focus on LG 2017, ZTE 2019, and RIM 2012. And in closing, InterDigital suggested as an unpleaded fallback case that the court should be using Mr Besant's future-only rates for LG. That's their written closing, paragraphs 370 and 434 at Bundle B, tab 4. So it is important to be clear when we're considering the various criticisms of the judge that reliance by InterDigital on future-only rates calculated from the 2017 LG license was never InterDigital's pleaded case. The case arose only in cross-examination of the opposing party's expert more than halfway through the trial. My lords, coming back to our appeal skeleton, in the core bundle at page 368, we reproduce a graph which is taken from paragraph 586 of the judgment, which depicts the comparable licenses. And this was known, as the judge recorded in the confidentiality judgment, this became known as the fjord graph because of the cliff at the right. So we have gone from Norway to Norwich with the graphs, and I'll be showing you the Norwich graph in a moment. My lords, it's important to be clear at this point as to which of the Lenovo 7 included any past sales in the analysis at all. Mr Speck made submissions yesterday as if they all did, and that is simply not right. My lords, we set out a table at paragraph 40 of our skeleton on page 373. And as the court will Samsung 2014, Huawei 2016 and Apple 2016 were not modelled or analysed on the basis of including any past sales at all. Samsung 2014 was unpacked by Mr Meyer on the basis that the entire licence fee was attributable to the future sales only. That's judgment paragraph 625 to 627. Huawei 2016 was analysed on a similar basis with only units and royalties after the execution date of the 26th of August 2016 at PKM 50. And Apple 2016 was unpacked by Mr Meyer on the basis of a future only rate because of uncertainty as to what past units had actually been released at all, a point that the judge deals with in judgment paragraphs 376 Roman 3, 377 and 657. The judge observed on a number of occasions in his judgment, for instance at 330 and 367, that on Mr Meyer's approach only LG 2017, ZTE 2019 and Huawei 2020 included any past sales.
How does that?
The reason Xiaomi has blended past future is that although InterDigital's account did not include any split, the judge held that a particular feature of the license, which is confidential, meant that it was correct to take past sales into account. And so the blended rate was the more reliable figure. That's paragraph 707. But even among those licenses with past sales, there is one example where the release period was quite short. That's Huawei 2020. The release was only a year and 4 months of past sales. That's judgment paragraph 688. And these are licenses which, as I've already observed, were assessed to be together the best group of indicators, with LG standing out as the best. That's paragraph 611 and 726 of the judgment. Now going back to the graph, which we see on page 368. Without reading out the rates, what we can see is if you assessed LG 2017, Xiaomi 2020 and ZTE 2019 on a blended basis, these are the blended figures for those licenses where there were past sales, then they produced rates which were very consistent with the overall pack of major licensees. The judge held that Apple 2016 was the outlier and was indeed useful only as an upper bound. That's judgment paragraph 661, as we shall be coming to. But on a straightforward basis, just taking the PV adjusted consideration and dividing it by how many units were expected to be covered by the license as a whole, the results were relatively consistent in terms of what InterDigital was in practice achieving in the market for its portfolio. By contrast, if you took future-only rates from the licenses where there were the largest proportions of past sales, and then looked only at the future rates, the implied rates went up dramatically in a way that was simply not reconcilable with the licenses where there were no past sales. And my lord, one can see that, my lords, one can see that from the Norwich City graph.
As I understand it, that's a point you're making rather than a finding the judge made.
No, my lord, the judge did find repeatedly, and I can get my lord all the references, that the future-only rates produced by applying the 10k split were, in his word, inflated. Okay? But my lord, in a sense, one can see that by comparing the field graph with the Norwich graph. And I hope my lords all have that graph. The first point to make about this graph, of course, is that these are rates after adjustment to Lenovo. And it was said that that is the right basis for comparison. We do not accept that at all. As the distinction between grounds A and B indicates, and as my Lord Justice Birss observed in argument yesterday, the first task is to establish what the licensee under the comparable license is actually paying. It's only thereafter that one needs to adjust for objective differences with Lenovo. These figures do not present an estimate of what these licensees are actually paying. They present an estimate of what the licensee would be paying if it had Lenovo's sales mix by standard and market, and if one uses a future-only rate. But, second point, one can see immediately by comparing this picture with the blended rates in the field graph that the licenses where there was the largest proportion of past sales are those where the implied future rate is highest and no longer sits in the range of the licenses where there were no past sales at all. My learned friend Mr Speck took you yesterday to tab 22 of bundle C, which was Mr Meyer's explanation of how he had accounted for the split between future and past sales. And one can see from that, at page 753 of that bundle, that ZTE was a license where 91.9% of the units on Mr Meyer's analysis were pass units. ZTE 2019 is the license at the far right end of this graph. It is also, as it happens, the only license among the Lenovo 7 which the judge also found to be an unreliable comparable. That's paragraph 687 of his judgment. The next license to the left is LG 2017, and if one goes back to Mr Meyer's schedule, one can see that that is the license with the next largest proportion of past sales, 70.2. By contrast, Huawei 2020 is a license where there was a much lower proportion of past sales, and one can see that it continues to sit in the range. So this graph, in a sense, simply illustrates the dangers of relying on future-only rates in isolation. And I shall, of course, be coming back to that.
Doesn't it illustrate how difficult all this is? Because the point, when the judge decided that ZTE was not a reliable comparable, that's because the rate was too low, and the rate he's looking at is the blended rate. In other words, the judge was saying the blended rate is too low. Not that the future rate is too high, but the two relate to each other. But if the blended, do you see what I mean? So it's all very well saying, to some extent, Mr Speck might be standing and saying, I agree, ZTE is not a reliable comparable when you use the blended rate.
Well, my lord,
that's the point that's been put against you.
I think, well, look, my lord, I think I'm right in saying that in relation to ZTE, it's not only the rate, think there is some consideration of the particular
Yes, he said, well, I mean, the paragraph you referred us
circumstance.
to is 687. He said, all these factors indicate the rate derived from ZTE 2019 is probably on the low side. And that InterDigital were anxious to get the money from ZTE, albeit a relatively modest total compared to bigger PLAs. For these reasons, I do not regard it as a reliable comparison.
No, that's right, my lord.
Exactly.
But what one then sees, with respect, if one goes back, that 685 and 686 are describing particular circumstances in which the license was concluded, related to sanctions and the such like, which lead to the inference which is drawn.
Okay.
And my lord, in the end, where this really gets to is the central question with all of these licenses, because they're lump sum licenses, is there any basis in the evidence for a finding that the lump sums were depressed below the Fran level?
Yes, well, I take the importance of that point, and we're going to come on to that, obviously, but just pursuing the theme that my Lord, or Justice Birss, was asking about. One conclusion you could draw from the submissions that you were just making is, as my Lord points out, you point to ZTE and you say, well, look, 92% pass sales. Judge says it's not reliable. Then you say, what's the next one with the biggest pass sales? Answer, it's LG 2017, 70%. And you say, and I understand why you rely on this, the others are much lower. But one possible conclusion from that would be to say, well, LG 2017 is not reliable. And yet, the judge's finding is that that's the best comparable, and indeed that is the comparable upon which he bases his own calculation, and you don't challenge that.
My lord, I think there are I need to address a number of different points there, my lord. Let me take them in turn. In relation to LG 2017, my lord put to me that one inference from the pattern I've just shown the court is that it's not a reliable comparable. That needs to be caveated because based on the Norwich graph, the inference that one would be drawing is that the future only rate derived from the LG 2017 license is unreliable. And that is a finding that the judge made. He found that the future only rate from LG 2017 was inflated. And in the absence, this is why I keep coming back to the lump sums, in the absence of any evidence or any finding that the lump sum in the LG 2017 license was depressed below the Fran rate. Indeed, that is not just an absence, there's a positive finding that there is no evidence that the lump sums in the Lenovo 7 were depressed below the true value of InterDigital's portfolio. The best and indeed the only reliable indicator of the Fran rate under those licenses is the blended rate. If the lump sum was Fran, then the blended rate was Fran. And what any unreliability of this graph tells you is that the future only rate being derived from the split, if taken in isolation, is not a reliable indication of the Fran rate.
Can I try and pursue that? Because that's a helpful submission. But in one sense, it increases my puzzlement, because your fundamental proposition from where you started, which I completely see the force of, is you say the best evidence is what is actually paid. So you look at these 7 comparators, you look at the real money that was paid, that was freely negotiated at arm's length between sophisticated parties, you say that's the best evidence. I quite understand the force of that submission. But the problem is that we know that in the case of LG 2017, in fact, a lot of the sales, in fact, more than two-thirds of the sales were passed. And I take it you accept we can't ignore that fact.
No, my lord, but that's why before lunch I was addressing this question in the context of the points made by Mr Javaharian, that the mere fact that one or other party to the license, or even both parties to the license, agree or indicate that the way in which they have arrived at the lump sum is, I shall give you a discount on past sales, doesn't tell you whether there is a non-FRAND factor in the license. There is a non-FRAND factor in the license if the lump sum has been depressed below a FRAND value. And that is a finding that the judge specifically did not make and rejected.
The judge decided ultimately that what was FRAND was for you to pay the same rate for past sales and future sales. Indeed, going back to the year dot, because the limitation point. Do you dispute that that's the right way to structure the amounts payable?
Well, as my lord knows, we have a cross appeal.
Yes, but that's that just deals with the more than 6 years old. But you don't appeal the decision that for sales up to 6 years before proceedings, so would not be impacted by limitation, you should pay the same rate as you do for future sales. You don't dispute that, do you?
No. But my lord, I'm not presently seeing how that impacts on this argument. I mean, when it comes to something like LG, there were, I think, 6 years and 11 months of past sales. There are other licenses where there were far fewer. Like, as I said, Huawei 2020 was, I think, a year and 4 months. There are variations between those licenses which had past sales.
Your point, as I understand it, is that actually the comparable data is the lump sum. It is X million paid for the entire thing, future and past. And it's, if you are going to proceed on the basis that what is FRAND is to pay the same for past and future, which is what the judge has decided, is your case as simple as this? The overall lump sum paid under LG 2017 is X. We know what the number of units that are assumed to go into that are. Therefore, that's what you pay for that number of units, whether they're past or future. And all you have to do is apply the same to us, and we pay the same for the same past and future, without distinguishing between past and future. Because if the overall rate is FRAND, and paying the same for past and future is FRAND, and if we pay the same for past and future at the same rate, that's FRAND. Is that your case?
Well, my lord, obviously we have many other points, so, but yes, the simple submission is that the judge's approach to unpacking was absolutely consistent with his approach to the settlement of our own license. As soon as one takes on board the finding that the lump sums are FRAND, that there is no basis for finding that the lump sums were anything below the true, well, I shouldn't paraphrase too much, appreciably or substantially below the true value of InterDigital's portfolio. In a sense, there's a missing link in my own friend's argument. It points to lots of general findings that there is this practice in the industry that people are aware of, that there is heavy discounting for past sales and the such. There was evidence of that, and we're not disputing that.
Well, not least, there was evidence from your own expert, which the judge accepted.
Quite much.
Isn't that the difficulty? I mean, I understand, let me say so, the simplicity of the point that my Lord Justice Nugee is putting to you, but it puts together two different questions. which is what did these people do? That's one question. The other is what is the Frand rate that you derive from whatever information you've got? And as I understand it, it's not in dispute that taking the LG as an example, I think it applies to others too, we know that there was a discount for past sales. And it's not in dispute that there was a discount for past sales. Your expert certainly didn't dispute that. He approached it on exactly that basis. So you can then derive a blended rate taking into account a discount on past sales, but that is what he was doing. After all, his past sales rate was whatever the number was, and his blended rate was a number that's bigger than that.
Well, my lord is right that those are the two numbers that Mr. Meyer produced.
Yeah.
I'm not sure it is right to say at that point, and in a sense, this is the key to this debate, because this language of discounts is used. It's really important to be precise about what one really means.
Right, lower price. I know that's a fair point.
Because
lower price then.
And that is the question, because there's evidence that in these negotiations, the licensee doesn't care how the licensor rationalises the lump sum. They just don't care. The licensor frequently rationalises their movement on the lump sum as I shall give you a discount on past sales. And the question is there are two types of discount. There can be a discount in the sense of the licensor saying, I'm giving you a discount on past sales, but what you're arriving at is a lump sum which is Frand, it's the market value. Or there can be a discount in the sense of a true non-Frand influence on the negotiation that produces a lump sum which is truly non-Frand, where someone has held out, delayed, utilised the fact that there's a large exposure of past sales to derive some kind of impermissible non-Frand advantage in the negotiation. But as we're going to be seeing, the judge considered at length the circumstances of each of the Lenovo 7 and concluded that there wasn't a basis for finding that the lump sums were depressed below the true value of InterDigital's portfolio. And in a sense, the test, we'll be coming to this, the control test of all of this is the licenses where there were no past sales at all. Because if the Frand rate is 49 cents, then I'm really handing up the details in due course. That implies that the lump sums, even under the licenses where there were no past sales at all, were massively too low. Not by a small amount, enormously too low. And there is simply no evidence for that. Indeed, it's a proposition that was rejected.
Do we see on this page we have open 753 percentage split for each of these licenses between past and future? Do we have a similar figure for your client?
There will be somewhere, my lord. As I stand here, I can't give my lord the reference.
Because you pointed out that ZTE, over 90% of their sales were past sales.
Yes.
Whereas Huawei's much less, and some are
Yes.
none at all.
We had a substantial proportion. I think you would put it reasonably close to the LG proportion.
I had a feeling it was about 2/3. If you look at tab
It's in our
18,
closing, I think, actually. Now I think about it. There were... no. Sorry,
I was thinking of page
Yes.
699 on
Yes.
tab 18 in the same bundle, which seems to have a total figure of 558, of which 375 is in the release period. Is that comparable to LG?
I think that might be LG.
That is LG.
I think it might.
That is LG. Yes.
Yeah.
So you're right.
We can get, my
all the numbers, and they're very large percentage in the past. But I wouldn't be misled by this. I think that is LG.
Yes, they are a substantial proportion in the past. The reason I don't think I should take my lord, because in our closing we did have a breakdown of this, and from recollection it was something like 3/4, 1/4. But that will have got appreciably
It would have changed because
worse
you've added in the
because
limitation.
of the exactly.
Yes.
I'm told that actually that you get it in tab 19. And if you were to look at the subtotal royalty base row, you've got the total for the entire period on the right hand side, 2007 to 2023.
Yes.
And if you come about the middle where you see the release total period, you've got a number beginning with a 6, and that's how much of that total number beginning with a 7 is. So it's actually
over 3/4.
Yes, but that's the number.
Thank you.
Going back to 2007.
That's the totality.
Yeah.
I'm told that there is a potential point of detail about the end point, but I think it's best that we get back to the course on that. The broad picture, I think we accept. My lords, we were on the Norwich City graph, and to draw out the point that was just being canvassed with the court, what one would expect to see if there were substantial true past sales discounts in the sense of a true departure from the Fran rate for the portfolio in the lump sums. What one would expect to see is that where one plots them as a blended rate, that's the field graph, the licenses with past sales are all lower, and that when you then, if ignoring the past is an accurate means of removing whatever depression there is, when you take out the past, you would then expect the rates to be returning to the norm, as it were, of licenses where there were no past sales at all. But that's not what happens. What happens is, if you look at them on a blended rate, they're all relatively consistent in a range that's very much consistent with the judge's findings. The point when the figures go haywire is when one starts using future-only rates based on the 10K split, when you start getting the figures that are in the Norwich City graph. And my lords, one final point, the third point on this graph, is the volume of sales box at the bottom. I mention that only because, as we'll be seeing, the judge explicitly and at some length rejected the idea that Samsung or Huawei or Apple should be getting substantial volume discounts, or indeed that such discounts were even a real thing at all. And we'll be seeing that, and there is no appeal against those findings. Now, returning to the field graph at page 368 of the core bundle, InterDigital wished, as we know, to get the rate well north of 50 cents prior to adjustment for Lenovo. And it sought to do that in essentially two ways. The first way, as we observe in paragraph 24 of our skeleton, was to argue that the only probative comparables were the red licenses with the smaller licensees or minnows. That was their pleaded case that I've shown the court. That sought to ignore the blue bars altogether. That was always an extraordinary case for reasons the judge summarised in paragraphs 609 to 610 and 793 of the judgment. These were not licenses InterDigital relied on in negotiations. None was in the top 20 handset suppliers. The scale and value of the licenses was such that they were more susceptible to hold up. In some cases, they hadn't even negotiated at all. They just signed up to the rack rates. These were not supported by any of InterDigital's witnesses. There were serious problems with comparability and reliability because of market exits, specialised handsets, etc. As I say, the judge gave detailed reasons for rejecting them as comparables, and there is no appeal.
Does it matter that the experts didn't? What exactly is it that's the role of the expert in that particular question?
My lord, this is a point that the judge addresses, and I can get my lord's reference, as to the difference between the nature of the evidence that was being received from the two experts respectively. Mr. Meyer applied a series of criteria to identify those licenses which were, in his view, more comparable than others. Now, clearly that didn't in any way bind the court. Ultimately, it's a judgment for the court. But that's the nature of the evidence Mr. Meyer had given. Mr. Bazant, it became clear when he was cross-examined, had taken no view whatsoever as to the relative comparability of any of the 27 licenses, and only made points related to their reliability, in the sense of how reliably can they be unpacked, and are there factors which might lead one to conclude that they've been concluded at an unduly low rate, and we'll be seeing the judge's findings on that. So there was evidence of two different characters before the court. But at any rate, in a sense, it doesn't matter, because I accept the decision was ultimately for the judge. The judge made his findings, and there is no appeal against that. So that first way of attempting to get the rate up did not succeed. The second way was a defensive case, which we describe at paragraph 25 of our skeleton, by which InterDigital sought to argue that the 7 licenses with the major licensees had all involved enormous discounts being given against the true frown rate because of the effects of holdout. And that case sought to raise the blue bars significantly, because this was known as the field graph. The technique was sometimes referred to as raising the sea level. My lords, Lenovo obviously submits that the accurate way of viewing the alleged discounts, and this is the view that was ultimately taken by the judge, is they were simply ex post facto rationalisations for the rates which had actually been achievable in the market. By contrast, what InterDigital sought to do is take the market price that had actually been agreed and then inflate it to account for discounts which it considered that it had given. And we're going to be seeing, when we look at the findings, that the alleged discounts, were there any substance to them, would have been measured in billions of dollars. Those were not contained in any of the license agreements. There wasn't any record of them anywhere. My learned friend suggested in his oral submissions that InterDigital had made separate, distinct, compartmentalised points, respectively, about the effects of holdout, the effects of discounts, and the effects of past sales. And that is simply not a fair account of how the arguments were presented, because the alleged discounts for past sales were dealt with as part of this overall architecture of unwinding various discounts which Mr. Bazant was asked to assume had been given to the licensees. Mr. Bazant's approach is summarised in a diagram at paragraph 301 of the judgment, which is at page 87. And the lump sum licenses, you can see on the right-hand side that they went through a whole series of steps between LSLER's licensee effective rates. He unwound fixed fee time value of money discounts. Then between common RR basis rates, he then removed past sales and unwound any volume, regional, term or renewal discounts. And these were all assumptions, as the judge explains and we'll be coming to. These were all just assumptions he'd been given. He hadn't tested any of them himself. They weren't in any documents. And what they had the effect of doing is massively increasing the market rate actually paid by the licensees and returning them, as one would expect, given that they were all based on InterDigital's perceptions of the discounts it had had to give against what it would like to achieve, returning the rates to InterDigital's preferred program rates, ultimately. So that was the technique that was deployed, and past sales were part of that process of unwinding discounts. The judge observes in paragraph 328, paragraph 328 on page 95. At the end of the paragraph, that in the expert evidence, the issue as to the appropriate treatment of past sales and the issues relating to discounts were rarely completely separated. One can see how Lenovo understood the case being advanced from our written opening, which is in bundle B, tab 3, at page 211. At paragraph 76, under the heading so-called discount. '76 explains the technique of trying to unwind these discounts. And 77 lists out, although they weren't written down anywhere, all the various discounts that InterDigital was suggesting it had given to the lump sum licensees. And one can see from 77.6 that past sales were part of that. I should say I don't know how we got to the figures very nearly I said the figures there. The figures that we attributed to Apple and Samsung, since they were ultimately not unpacked on the basis of having any past sales. But the only point I make is that past sales were treated as part of this overall architecture.
Isn't that the point? Is that what you were attacking here was the supposition of discounting from the so-called program rates on a variety of bases. And that's why you get figures being given for Apple and Samsung, which apparently don't apply because there weren't any past sales. And this is, as you rightly say, the judge rejected these as being ex post facto rationalisations based on subjective views, and moreover, he thought the program rates were unjustified. Take all of that, but isn't that actually, upon analysis, a slightly different issue? It's one thing to say InterDigital's program rates are unjustifiably high. Moreover, their attempt to massage that in presentation through the use of so-called discounts, which are rationalised on a variety of different bases, but most of all on the basis of volume. That was the key one, but it wasn't the only one for sure, as you rightly say. That's all one thing, and you won on all of that, and there's no challenge. But then isn't there a different point, which is, well, when we look at LG 2017, and we see that there's 70% past sales, how do we unpack that? Why isn't that a different issue?
Well, my lord, it's obviously a different alleged discount, but to it we apply the same analysis, i.e.
But then Mr. Meyer would have said, never mind all this rubbish about discounts, because it was Mr. Meyer's evidence, which the judge accepted, that the way in which the assumed discounts, I think that was Mr. Meyer's phraseology, the assumed discounts were being used to try and justify the program rates. And he said, this is all nonsense. And yet, when it came to unpacking LG 17, he did think it was appropriate to try and differentiate between past and future.
Well, my lord, he did produce distinct rates, it's true. But as we will see, both in his written evidence and in his oral evidence, he was very clear that he counselled against looking at the future rates in isolation, because what that would give you is an artificial inflated rate. He was very clear about that.
Okay, thank you.
But my lord, as I say, we ultimately apply the same analysis. The starting point is the true market value is the value embodied in the lump sum agreed between licensor and licensee. If one is then asking, was there a discount which ought to affect the analysis, it has to be a discount which impacted upon the lump sum and gives rise to a legitimate inference that the lump sum was non-frowned. It cannot be simply an assumption handed by InterDigital to its experts that we think we gave a discount of X% for this and X% for that, and the result is that the true fran rate is multiples of what we actually managed to get in the market. And of course, my lord, I'm reminded that not only was Mr. Meyer clear that the correct approach was not to take future rates in isolation, that was also the judge's finding. But my lord, I was addressing the question of whether this issue of past sales was really ever put in some kind of separate box, distinct from holdout and delay and other points by InterDigital. And we say it wasn't. And one can see that again, for instance, if one remains in Bundle B, in InterDigital's written closing, at tab 4, page 298. This is a section entitled Holdout and described as the asymmetrical effects of delay on the patent holder and the resulting downwards pressure on royalty rates, including discounts for the past. We can see that from 55 and 56 that this is an attempt to deal with the problem of holdout and to address that topic. And one sees over the page at page 300 from paragraph 61 that the case being made was that it was the risk of holdout that pressurises SEP holders to give discounts for past sales. That's one way to get a deal done, etc. So we say that the idea that there was some sort of distinctly pigeonholed point about depression in past sales rates, which was somehow independent from complaints about holdout, delay, and the such like is simply not right. Likewise, paragraph 66b was reference to this whole question of discounts for the past having arisen from holdout. So that was the second way that InterDigital tried, by reference to the field graph, to get to its preferred rate of 50 cents a unit. So that was InterDigital's case at trial. Lenovo's case at trial is summarised in our skeleton at paragraph 27 onwards. That's page 369 of the core bundle. Giving the court the references to the judgment at paragraphs 28 and 29, we summarise the basic position, relying on the licenses with the largest implementers. Paragraph 30, we record the point, which I shall obviously be coming back to, about Mr Mellor's evidence on blended rates. And then in 31, we set out his diagram. Now, my learned friend made a point here that Mr Meyer's adjustments were in fact applied separately to past and future numbers before he blended them back together. That is true. But that was simply, as indeed my own friends observed at one point, an effort to apply the economic adjustments in a more accurate manner by reference to the different time periods covered. Lenovo's business is of course not static in its relevant characteristics. And if one can perform the adjustments with greater granularity over time, then obviously that's preferable. And indeed, as the judge records in his judgment, after deliberation, he asked whether there was another different way of doing it by reference to 3 different time periods. The critical point, though, is that the end result remained a blended number, not a future rate taken in isolation. And as one can see by comparing if we take the blended rate rows, I'm not going to read them out, but the effect of the economic adjustments depended naturally on the relative characteristics of the licensed businesses. So with some licensees like Apple and LG, which had a greater proportion of handsets complying with the latest standard in developed markets, the effect of the adjustments was to bring the rates down significantly. For others, such as ZTE and to a small extent Samsung, they worked in the opposite direction. But ultimately, our case was, indeed is, that those licenses embodied the kind of market rate that the comparables approach looks for and that other cases have looked for. And indeed, that this is the exact bracket of licensees that InterDigital itself had pointed to in negotiations with Lenovo. That's a point made by the judge, paragraphs 8, Roman 1, and 610 of his judgment. And they were indeed found to be the best group of indicators of the value of the portfolio, avoided indicators. The third main topic was the judge's findings. Let me, for now, just direct the court to the summary in section 2D of our skeleton argument. What we tried to do in paragraphs 33 to 42 is to draw together the findings on the key issues. And an important point to note is that because of the interrelated nature of a lot of the issues, the relevant findings on a given issue are not always to be found only in one place. What we've tried to do is bring together the findings cumulatively by topic. But beyond that, I think it's more convenient, to show you the parts of the judgment on which we particularly rely as I develop the argument. So let me turn to the fourth of my main topics, which is the correct approach to the appeal. We deal with this at paragraphs 46 to 47 of our appeal skeleton, and I would refer the court to the Lifestyle Equities case, which is in the Joint Authorities at Volume 3, tab 36. This was a recent decision of the Supreme Court in a trademark infringement case about whether marketing and sale of goods via Amazon's US website was targeted at consumers in the UK and the EU. And the relevant part is at paragraph 46 onwards, page 1117. Headed the correct approach on appeal. In the second line, a finding that an activity is or is not targeted at consumers in the UK necessarily involves an evaluation by the judge, paragraph 46, of a range of different facts and matters. It requires, in other words, a multifactorial assessment of the documents, the evidence, and the submissions made by the parties. The evaluation is also one which, when made in that way, the trial judge is peculiarly well placed to carry out. At 47, there's reference to the disadvantages at which an appeal court finds itself. And there is then at paragraph 48, citation with approval of the very well-known observations of Lord Justice Lewison in the Fahe and Chobani case, which I know the court will be very familiar with. The first being the reminder not to interfere with findings of fact, and that applies also to the evaluation of those facts and the inferences to be drawn from them. And then the various reasons are given. And the fourth is one that I've alluded to already. In making his decisions, the trial judge will have regard to the whole sea of the evidence presented to him, whereas an appellate court will only be island hopping. Fifthly, the atmosphere of the courtroom cannot in any event be recreated by reference to documents. And then 49 makes the important point that the appeal court is not powerless to intervene, nevertheless. Third line, it may be possible to establish that the judge was plainly wrong, or that there has been a significant error of principle, but the circumstances in which an effective challenge may be mounted are not limited to such cases. And there's reference to In Re Sprint Room. And it said, on a challenge to an evaluative decision of a first instance judge, the appeal court does not carry out the balancing exercise afresh, but must ask whether the decision of the judge was wrong by reason of identifiable flaw in the judge's treatment of the question to be decided, such as a gap in logic, a lack of consistency, or a failure to take into account some material factor, which undermines the cogency of the conclusion. And in 50, it said it's not enough to arrive at a different evaluation. My Lords, the assessment of an appropriate FRAND rate for a licence to Lenovo under InterDigital's 3G, 4G and 5G portfolio is, in a sense, a classic example, in my submission, of a multifactorial assessment of the documents, the evidence.
I don't think that's in dispute. I don't think it's in dispute that deference, or not really deference, but that caution is required, as you say, based on lifestyle.
And my Lords, the conclusion which is attacked in this case, the urgency of which needs to be undermined, for the reasons I've already shown the court, is the conclusion that 138.7 million was a FRAND lump sum. Indeed, given that InterDigital is asking this court to substitute a lump sum of 388.5 million, one assumes that it's being said that the nature of the alleged error is one that leads inexorably to an evaluation that that was the FRAND lump sum instead. And we say grounds A and B identify no such error. That brings me to the fifth main topic, which is the reasons for rejecting grounds A and B. By ground A, InterDigital argues that the judge derived the wrong rate from the LG 2017 license. It says that the FRAND rate, which should have been extracted from that license pre-adjustment, was 61 cents rather than 24 cents. That's grounds of appeal, paragraph 4. And the starting point here is the amount agreed between InterDigital and LG as the consideration for the license. We don't need to go back to it. We saw it earlier today in Bundle E at tab 9, page 54. The consideration agreed in the license was a lump sum, a staged lump sum, for the license and for a pass release. But ultimately, all that was agreed between the parties as a result of the process of negotiation and compromise was a lump sum. My lord, on Mr Meyer's analysis, which took the total number of units covered by the license and divided the consideration by that number, the per unit rate, and this is the one preferred by the judge, was 24 cents, as we know. And as we'll be coming to, Mr Meyer's strong view was that attempting to leave the past sales out of account and look only at his future only rate would give you a misleading picture. I'll come to that. But it's possible just to orient the argument and using the number of units covered, which the judge generally preferred, Mr Meyer's analysis, paragraph 673, to identify what the lump sum InterDigital's appeal would imply LG should have paid would have been. And we've done that in a handout. Can't read out any of these figures. But what I can say is the top line is the total units. The second line is what the lump sum, in inverted commas, should have been if the FRAND rate under this license was truly 61 cents. And below that, what the actual consideration was. My lords, InterDigital's appeal necessarily entails a conclusion that the LG license was concluded at a rate which was hundreds of millions of dollars less than was FRAND.
But that's precisely the argument. I mean, it's good to have the figures, and I'm grateful, but that is indeed Mr Speck's very argument. His case is that it was indeed depressed from the past.
I understand, my lord.
And you pointing out that Mr Meyer's view was that the blended rate was the right rate. Obviously, it was the right rate if it wasn't affected by unFRAND factors. But it doesn't tell you whether. It's what do you do if it was affected by unFRAND factors.
Well, my lord, I understand that, and my submission will be that the judge's findings on this issue couldn't be clearer. The lump sums in the licenses, there was no basis for supposing they were below the true value of InterDigital's portfolio. And I understand that Mr Speck's case is indeed that this license was concluded for hundreds of millions of dollars less than it should have been. if the Fran rate is 49 cents, that's said to be the Fran rate after adjustment, then the conclusion is so too were all of the others. Well, with one exception. Let me hand up a further document.
Sorry, just before we leave this one, just this second, I can't remember what PV stands for. I do know it. But
Present value.
Thank you. Thank you.
Well, this is taking all the others and doing a similar thing. If the Fran rate were really 49 cents, what should these licensees have been paying? And we see that from row C, compared with what they actually paid in row D. And my lords, I emphasise, and I'll naturally be coming back to this, the three on the left are licenses where there were no past sales at all in the analysis. And the next one along is the one that the judge found was useful only as an upper bound. So my learned friend's rate case on appeal necessarily entails, in our submission, a conclusion that the lump sums paid by the Lenovo 7 were in almost every case massively below a true Fran rate. And that is true even of those licenses where there were no past sales at all.
Sorry to interrupt you, I just want to understand, is this an adjusted, you adjusted this? I'm not sure these are, you'll find Lenovo adjusted rates to Samsung.
No, this is the 49 cents that is said on appeal ultimately to be the Fran rate that the judge should have settled for Lenovo. But of course, have constructed this comparison on the basis of the 61 cents prior to adjustment, which, as we submit and as I submitted earlier, is in fact the correct basis to compare between licensees, because it compares what they're actually paying. But as we know, Mr Speck takes issue with that, and so for the purposes of this comparison, we use the 49 cent rate, which is the rate that the court ultimately asks, is ultimately asked to settle. My lords, we say that proposition cannot be made good on the evidence and is indeed inconsistent with all of the judge's findings of fact. And we do say ground A should be dismissed for the 8 reasons that we developed from paragraph 51 onwards in our skeleton argument. And just to summarise them, firstly, we say ground A is inconsistent with the judge's findings of fact as to LG and the Lenovo 7 more generally. Secondly, ground A is inconsistent with the rates to be derived from the remainder of the Lenovo 7. Thirdly, that ground A arises from a deliberate decision to advance a jackpot case by InterDigital and to give the judge no moderate way of quantifying the effect for which they contended. Fourthly, that the argument is inconsistent with the evidence of Mr Meyer. Fifthly, that it would involve resurrecting an important aspect of the approach of Mr Besant, which was found to be less reliable than Mr Meyer's. Sixthly, that ground A is inconsistent with the approach of the US District Court in TCL and Ericsson, which also considered the issue. Seventhly, that ground A is in no way supported or rendered mandatory by InterDigital SEC filings. And eighthly, that ground A would involve setting a rate that would breach the non-discrimination element of FRAND. My lords, let me develop each of those arguments in turn. The first one is inconsistency with the judge's findings of fact as to the LG license and the Lenovo 7 more generally. I've already explained the necessary premise of ground A is that the lump sums in the Lenovo 7 were massively below FRAND. And that is a proposition that was expressly rejected by the judge on the facts. We're given the references at paragraphs 53 to 55 of our skeleton argument. And I'm going to take the court through a number of the relevant findings. So first of all, we need to go, please, to paragraph 360 at page 106. This is dealing with the second element of InterDigital's approach in relation to the discounts. 361 sets out Lenovo's basic contention that the PLAs with the largest implementers fall in a range which is multiples below InterDigital's headline rates. 362 is the suggestion from InterDigital in opening was that all these deals with the larger players resulted from holdout. See the quote in paragraph 355 above. This is a critical issue which I'll examine later. By contrast, Lenovo submit that the license rates agreed with InterDigital's 6 largest licensees are on InterDigital's own evidence the result of a compromise between willing licensor and willing licensee and the best evidence of a FRAND rate. 363, in summary, therefore, Lenovo relied on Lenovo 7 as a basket of the best comparables, analysis of which provided a market rate. So the judge was expressly identifying an issue as to whether the deals with the larger players were or were not the best evidence of a FRAND rate. Now, before we come to the specific findings on that issue, I need to show the court the findings on volume and other discounts. And for that, we need to go back to paragraph 321 at page 93. And this is just to illustrate the scale of the discounts which were being contended for. I'm not going to read the figures, but one can see from 322 that the assumptions as to the discounts which had been given to Samsung were very large numbers indeed. So it was said that Samsung's rate was very substantial rates below FRAND. We can then go on back in the discussion to 458 at page 127, which is where the discussion of volume discounts begins. And the judge summarises the scale of the volume discounts said to have been given. We can see from 459 that the evidence was that these discounts had been necessary to avoid holdout by larger companies. We have Mr. Javahirian's evidence summarised at 463 onwards. In the fourth line of 463, Mr. Javahirian argues that what matters to companies engaged in set licensing negotiations is the effective rate paid by any given licensee. He says that for most licensees, this is primarily a function of the total amount paid in unit volumes, This, he says, is the reality of the value which has actually changed hands under the transaction. And we can see, I shan't read them out, but the next 3 paragraphs set out his evidence on this point.
Yeah, and so the bottom line is that the judge rejected the case on volume discounts. But could I have your submission on what he says at 493 and 494?
Yes, my lord.
So the point he makes there is that InterDigital were only allowing volume discounts for sales made during the term of the license, and that wasn't a point that was always appreciated. So in other words, it was a separate point for whether one calls it a discount or not, but it was a separate point from past sales.
My lord, I'm not taking issue with the proposition that volume discounts were a different category of alleged discounts from past sales. The reason I'm drawing attention to this is that this was the first way in which it was said that Samsung, Apple, and others had received deals that were enormously below the allegedly true FRAND value. And my lord, just to draw out the point at 493 and 494, the stipulation that volume discounts did not apply to past sales was entirely a function of InterDigital's rationalisation of what ought to happen. There was, as the judge found, and we'll be seeing, no evidence that these discounts were ever actually written down or discussed with anybody at all. And it was a stipulation imposed by InterDigital that you could only get a volume discount, allegedly, on future sales. But there was really no evidence of this actually being a feature of the negotiations at all.
Yeah, well, and that's what he says in 495 and following.
Indeed, my lord. Their primary purpose, 495, is to attempt to shore up InterDigital's chosen program rates. Their primary effect is discrimination against smaller licensees, etc. 496, there are no economies of scale. And 498, at best, the arguments can only justify relatively small volume discounts where, for example, the overall transactional costs, including the costs of litigation, are of the same order of magnitude as the quantified discount. So we are talking about very small amounts that the judge decided might be consistent with FRAND. And the reason for that is 499, that the sizes of the volume discounts used by InterDigital discriminate against smaller licensees. So it is not open to my learned friend to say that the explanation for the Samsung, the Apple, or the Huawei 2016 lump sums is some kind of enormous volume discount. Nor indeed of any of the Lenovo 7 where the volumes were larger than Lenovo's. And 503 is the point about classic ex post facto rationalisation, fourth line, designed to convert the actual rates charged into something else. This exercise is far removed from what those in the market actually do, which is, as Mr Meyer described, to take the overall lump sum and the best estimate of the units involved. The other discounts were then considered from 508 onwards. And we can see Mr Bazant's analysis described in terms of the diagram that we saw. And we can see in the fifth line, the second category of discounts were licensee specific. So, to go from his CBRs to his PDRs, he A, removed past sales, and B, unwound the assumed volume, regional term, or renewal discounts. So my lord, past sales is certainly mentioned there. There's extensive consideration of this, and one gets my analysis at page 140 onwards, paragraph 516. And 519 is the conclusion. Third line, any other discounts, i.e. which do not reflect the time value of money and which were assumed by Mr Besant to have been applied, I put in the same category as the volume discounts, because it seems to me they were used along with the volume discounts to shore up InterDigital's program rates and therefore contribute to the discrimination against smaller licensees. So the argument that the lump sum licenses had all been concluded at a value far below the true value because of all of Mr Besant's discounts that he applied, including his unwinding of past sales, is rejected. And there is some further content as to how these...
and do you say that in rejecting Mr Besant's approach to past sales, the judge was also rejecting Mr Meyer's approach to past sales?
No, my lord.
In this passage. I mean, in a sense, he does reject it later, but I'm talking about specifically in this passage.
Well, my lord, will be... Yes, so we're coming to it, but the judge was given two approaches. Mr Besant's approach, which was the only approach he was ever offered by InterDigital for dealing with the problem that it perceived, was simply to ignore past sales altogether. Simply to take them out and use only the future rate. That is what is being rejected here. Mr Meyer's approach was to calculate separate rates, but always to present them together, always to present a blended rate, always to make clear that he preferred the blended rate, and always to make clear that unless there was some specific reason why you had to do it, which is the case in respect of Apple 2016, not to use the future-only rates on their own, because they were inflated and artificial. My lords, there's a description of the negotiation process that we can see at page 147. Under the heading of about subjective views. 553 is making the point about subjective views on the discounts. And in the fifth line, we see that he formed the view that the overriding consideration for InterDigital in the negotiating and agreeing PLAs was to achieve the maximum money from the licensee, whether by way of lump sum or running royalties. He says that's not a surprise. At the same time, I recognise that the overriding consideration for each licensee is to pay as little money as possible for the licence. Overall, and for various additional reasons relating to more detailed points to which I set out below, I do not consider InterDigital's approach was frank. And my lord, we submit that that's a reference to the point he comes back to on many occasions about discrimination against smaller licensees, because what we have seen from the field graph is that the effect of InterDigital simply trying to get as much as it possibly could from anybody is that smaller licensees who were less able to defend themselves or had fewer resources to be able to defend themselves signed up for rates which were dramatically in excess of what was being paid by the major licensees. Well, we can then go forwards to page 157.
Well, just before we do that, I mean, we've discussed this to some extent already, and of course, as you pointed out earlier, you've got your cross appeal. But can I just have a look at 556? Because what he says there is, assuming he's right that limitation periods are irrelevant, he says that has certain consequences. One, Lenovo has to pay for past sales. And another consequence is that one of the two principal reasons he has been able to discern as prompting the practice of heavy discounting of past sales has now, that is to say, as a result of his decision, been removed. And of course, we have to assume for this purpose that he's right about limitation periods, contrary to what you're going to argue on the cross appeal. On that assumption, what do you say the judge should have done in order to eliminate the effect that he has found did have an impact in the past wrongly?
My lord, I think the starting point is the point I made earlier, that as regards some of the licenses where there were past sales, limitation won't have been an issue at all. Huawei 2020 is the example of that. That's a year and 4 months. LG, it's 6 years and 11 months of past sales. So we're not talking about a tail, much of which would have fallen outside limitation.
Yeah, but that's an argument he was wrong to take LG 2017 as the best comparable. And you don't have any respondent's notice saying he was wrong on that point.
No, my lord, we're certainly not saying he was wrong to take it as the best comparable. And my lord asked me the question, what can a court do in that situation?
Yeah.
And our submission, I come back to the point I made earlier. The way that the court can test for this is to examine, as the judge examined, whether there is any basis for concluding that the lump sum in the license was non-FRAND. Because we know that in some cases, in negotiations, people say, past sales, I'm giving you a discount on past sales, and it's just a way of rationalising moving towards a FRAND lump sum. And the way that one can test as to whether one is in that camp or one is in the camp of a truly non-FRAND factor impacting the negotiation is by examining the circumstances and deciding whether there are any indicators that this license was concluded at a rate below the FRAND
Okay,
level.
can I summarise that submission in my own words to see if I've understood it correctly? What you are saying is that even though the judge has found as a fact that in the past there was a practice of heavy discounting of past sales, which, due to particularly limitation periods, which is non-FRAND, you say nevertheless, despite that, the evidence shows that the judge found that at least some of the comparables he relied on were not affected by that factor. Is that what you're saying?
Yes, but I would put it slightly differently. That there is, based on the judge's findings, there is no basis for concluding that the lump sums in the Lenovo 7 were affected by a non-FRAND factor. And in a sense, as I come back to it, in a sense, the control test is the licenses where there were no past sales at all.
So when the judge refers there to the practice of heavy discounting of past sales, is there any finding on your case, of a license that he's asked to examine, which contains the practice of heavy discounting of past sales as being non-frowned.
In relation to these particular licenses, no.
Right, and well, these particular licenses, you mean the licenses in the case?
The Lenovo 7.
Okay.
The reason for that is that some of them have no past sales at all. For those that did, there is a variation in the tail.
Okay.
Some
so
of them
what's
is
the
a
judge referring
relatively
to?
small.
Just help me, seriously. What's he referring to in 556?
He's referring to evidence, of which there was plenty, that in negotiations, people frequently say, I'm giving you a discount on past sales. When parties are saying, I'll offer you 250 million, and the licensor says no, we'll take 200 million or whatever. The licensee doesn't mind, doesn't care. The licensor says, I'll give you a discount on past sales.
Well, I take that point, and that's very clear. But can I put my Lord's question a slightly different way? In the case of the Lenovo 7, some of them you say, no past sales, that I understand. But the judge has made a general finding that all past negotiations in this field have been affected by this point on limitation periods. Was there any evidence, or more specifically, any finding by the judge that the negotiations on the Lenovo 7 were not affected by this limitation period consideration, even though he's made a general finding that everybody else was?
Well, my Lord, I'm going to be going through the findings, and we say where one gets to is having considered all the arguments that these licenses were somehow impacted by holdout or delay or non-Fran factors and were concluded at a rate substantially below the Fran value of the portfolio. The judge comes to the conclusion that there isn't any.
Isn't the real problem that one simply faced with this judgment, one has two inconsistent findings? That's what we have. We have a finding here by the judge that there was a practice of heavy discounting which was unfrowned. And then when we get to the other bit of the judgment, many hundred paragraphs later, or before, I can't remember, it doesn't matter, he when he had his blinkers on looking at the particular license, the judgment doesn't find that factor happens in those licenses, which is, one might say politely, inconsistent with the conclusion in paragraph 556 that there is such a practice.
Well, no, my Lord, and we would say the reason for that is this. I come back to the point. There was evidence, and there was a whole argument about discounts to the effect that there was a difference between a true discount in the sense of a departure from the true Fran value of the portfolio and a notional discount in the sense of a rationale articulated in a negotiation for movement in relation to a lump sum. And the whole argument about discounts was, were these a real thing? Did they involve movement by billions or hundreds of millions away from the true value of the portfolio? Contrary to what would ordinarily be the inference that one would draw from a comparable between a willing licensor and a licensee. Is that the case? Or were these, in fact, simply rationales or articulations of justifications from one side of the negotiation for movement on a lump sum?
So your submission is that 556 is about rationalizations.
Well, yes, but what is more, the submission certainly is that cannot trump later specific findings in relation to the licenses. Point one. Point two, if one wants to test for that, look at the licenses where there were no past sales. and ask, is there any credible rationale for the missing hundreds of millions, or in one case more than that, that would be implied from the lump sums in the licenses where there were no past sales at all, if the Fran rate were really 49 cents, a rate extracted from a future-only rate, which depends on all of the issues about the split, and which the judge found was inflated.
When he refers in 556 to principal reasons which I have been able to discern as prompting the practice of heavy discounting, that's a reference back to something he said earlier. Where has he said it earlier?
It's in a number of different places. I don't have a reference to hand, but I think I'm right in saying that the two different factors that he referred to were limitation periods and difficulty in recovery on a global.
What, specifically the need to sue territory by territory prior to unwired planning?
Yes. Yeah. Now we do say, in a sense, the real question is whether there's any evidence that whatever the practice of notional discounting and inflation of the agreements, any of the Lenovo 7 were unfairly depressed as regards their total consideration. And the finding is that they were not, and as I say, the controllers agreements where there were no past sales at all. My Lords, moving on to the later parts of the judgment, paragraph 600 at page 157. We see that InterDigital put forward a series of arguments as to why the Lenovo 7 were not reliable comparables. And we don't need to look through all of them. There's reference to the fact that they're lump sums, the discount point in 604, and then 605. InterDigital's third point is that the original 6 of the Lenovo 7 PLAs can be assumed to be depressed or distorted due to various factors, of which the common and most prominent factor was said to be holdouts. These arguments were conveyed in Mr Bazant's evidence. It is appropriate to deal with them in the context of each lump sum PLA below, and then in my overall conclusions on this comparables part of the case. And we can see 606, there was reference to the effects of volume being baked in. My Lords, I then need to take each of the licenses in turn. Samsung starts at 625 on page 162. There is detailed consideration of all of the facts. Mr. Alexander took you through this earlier. Mr. Bazant's figure for this license, it hasn't been highlighted in my one, but I'm not going to read it out because I think it probably should have been, is at 630 subparagraph 1. There is consideration from 6.
Sorry, you said Mr. Bazant's figure. It's
Sorry,
Mr. Myers' figure.
I apologise. Misspeaking, my lord. Mr. Meyer.
Yeah, just wanted to check I wasn't misreading.
That's quite right. And we can see that Mr. Bazant 631 had a section with the heading Factors Affecting Reliability and Relative Comparability, and he listed them all out. It's talking about the coattail effect, etc. 634, you can see that one of the points that was made was past sales treatment. And the judge says, however, Mr Bazant's figures showed, in my view, an insignificant difference. So this is a license where past sales are simply not an issue, and the 7 factors are considered. I won't go through them all. 635, the judge makes the general point that Mr Bazant's factors were all presented as neutral or indicating that InterDigital had to accept a lower rate. And then he discusses all the manifestations of that. 641 on page 167. In view of the overall exercise in which Mr Bazant was engaged, i.e. taking account of all of InterDigital's subjective views of its PLAs, and in particular assuming all of the discounts that were potentially available were applied in a uniform fashion in order to derive his CBRs and PDRs, it is perhaps not a surprise that Mr Bazant was unconsciously programmed only to find downward pressure on InterDigital's rates. And 642 to 645, I think you saw earlier with Mr Alexander, the conclusion at 642 was that there were indications that the rate was slightly low, and 645 somewhat depressed. Now this is a license with no past sales at all, so we know that's not an issue in it. And if the true Fran rate were 49 cents, then slightly low or somewhat depressed would plainly not begin to describe the disparity with the rate to be derived from that license, which we see at paragraph 630, subparagraph 1. It would not begin. Now, I'm going to, for each of these licenses, then move forward in each case to the judge's ultimate assessment of the various licenses at page 196 onwards, in a section headed Conclusions on the Comparable Licenses. The judge considered all the licenses in aggregate. At 795, he explains why there is reason for caution as regards Samsung 2014. And at the end of the paragraph says there's reason to believe that the rates implied by the Samsung license are somewhat lower than the Fran rate for InterDigital's set portfolio of 2014. And I make the same point as I did about slightly low or somewhat depressed. And one can see the sort of scale he had in mind in terms of somewhat lower from the next paragraph, which considers Huawei 2016, another license where there were no past sales, and the rate that he finds acts as a counterbalance to the somewhat low rate in Samsung 2014. So that's the corridor that the judge is identifying based on 2 licenses with no past sales in the analysis at all. And at paragraph 805 at page 198, when making his judgments about LG 2017, he specifically takes into account where it sits in relation to Samsung 2014 and the other licenses as regards the period 2012 to 2018. So The judge's evaluation as to the rate to be derived from LG and that it was the best comparable was expressly reached on the basis of a process of setting that in the context of the other licenses and the rates that could be derived from them. And particularly, I emphasise, rates from licenses where there were no past sales. We can go back then to Huawei 2016, which is paragraph 646 at page 167. We can see Mr. Meyer's effective rate at 647 subparagraph 1. At 648 to 653, there was consideration of the various factors that Mr. Besant had put forward as leading to the conclusion, the factors on reliability. And at 654, we can see the ultimate conclusion in the last two sentences. Mr. Besant suggests that InterDigital may have accepted lower rates to conclude the deal. However, the rates derived by the experts from Huawei 2016 do not reflect that, in my view, even though they are lower than Apple 2016. So again, a finding that the rate at 6471 did not represent a lower rate to conclude the deal. And no past sales. And as we saw from paragraph 796 on page 196, it was this license that was the counterbalance to Samsung 2014. And again at 805, it's taken into account for its consistency with LG 2017. Page 198, paragraph 805. Apple 2016 is at paragraph 655 onwards, page 169. There is detailed consideration of the circumstances of the Apple license. Mr. Meyer's rate, the point I've been making about why Mr. Meyer had to use a future-only rate for this license, you can see from paragraph 657. In other words, it simply wasn't possible to determine the number of past sales. So 6581 is Mr. Meyer's rate, which, because it's a future-only rate, by definition doesn't have any past sales in. Again, I won't read it. And the judge is explicit at 6584 that he proceeds on.
Sorry, just going back to 657, can I just check I've understood what the judge has said there correctly? I'm not suggesting you've in any way misstated anything. I want to be sure I've understood. So what happens is that InterDigital recognised $141 million of past sales in its Form 10K, and Mr. Meyer dealt with that by deducting that amount from the 2017 payment. So that's consistent with his general approach as taking the Form 10Ks as reliable. But then the problem we had was, how can I unpack that in terms of a dollar per unit, because I don't have any reliable figures for the numbers of units. Have I understood correctly?
That's precisely right.
Yeah.
And so, in this one instance, Mr. Meyer was compelled to take the course that he ordinarily said one shouldn't take, i.e. using a future-only rate, because there simply wasn't, in isolation.
Well,
because there simply
except it wasn't really a future-only rate, because he deducted the amount of the past sales from the payment. It's a rather rough and ready approach, but one can understand why he did it if he didn't have any reliable data for past sales. It's not as if he was saying you ignore the past sales. On the contrary, he took what was in the Form 10K and did with it what he could.
Yes, that's true. But then the corollary of that was that the future rate that he was using was constructed purely on the basis of the forward-looking consideration divided by the forward-looking units.
Thank you.
So Mr. Meyer wasn't dogmatic about this. If he had to, then he proceeded on that basis, but he was clear, as we'll be coming to, that was not his preferred approach. The judge proceeds on the basis of Mr. Meyer's rate, 6584. (661) Due to Apple's unique status in the market, I doubt that Apple 2016 is a useful comparable. The rates derived from it may nonetheless be useful as indicating an upper bound. I doubt that Apple 2016 represents a depressed rate. So, my lords, the rate that we see at 6581 is found by the judge to be useful as indicating an upper bound. And that is the same finding which is made later on in paragraph 797.
With these lump sum licenses, when you've got a lot of future, does it work by the estimate of the units being what's actually been sold, or does it work by the estimate of the units being what the people thought they would sell when they signed the agreement?
I can make sure I get that right, but from recollection, if you're working on the basis of facts which already lie in the past, then you will assume that negotiating parties would be using actual data.
But the people who negotiated Apple 2016 didn't know what Apple were going to sell in 2017, 2018. I'm just reflecting on the fact that there's quite a lot of future in that Apple 2016 license, and therefore there's an increase in the unreliability of whatever exercise you carry out. Because what you're interested in fact, is what did they think when they signed the license? That's what you're interested in. And if Apple's sales over that period were lower than they had expected, but you use their actual sales rather than their expected sales, you'll get a higher rate. And vice versa, of course.
I'm sorry, Michael.
I mean, it applies to everyone. It's not about Apple in particular. It's just I noticed there was a lot of future there.
My lord, as regards the future, I believe I'm right in saying that we use projections based on objective evidence from, there's a great deal of third-party coverage of these markets. Because that is data, as my lord adverts to, on the basis of which one hypothesizes the willing licensor and licensee would have negotiated. As regards the past, you're obviously in a different position because there would actually have been material available.
Yeah.
But that, my lord, is a feature of unpacking any lump sum, which includes, as they all do to a greater or lesser extent, the future.
Yes, and because there was no disclosure as to the negotiating history of any of these licenses, we don't know what projections the parties were actually using. So if I've understood it correctly, the assumption made was they would have used the best available projections from the market.
Yeah, I think that was Mr. Meyer's approach. I think it's fair to say that, from recollection with Mr. Besant, the position was rather more complicated because in some cases...
Yeah. But I think in the end, InterDigital agreed to use the IPC figures, which were taken to be, so far as the past was concerned, historic actual figures, and so far as any future projection, it was assumed that that's what people would have projected.
Yes, I think that's right. Mr. Besant started out trying to use some more negotiation-specific documents, but then ultimately arrived at the position that, that the projections were the right thing to use. So, my lord, Apple 2016, there is and I do make the obvious point that here there is a finding as to what the upper bound was. And it is entirely inconsistent. I can't go into the details because it's confidential, but it is entirely inconsistent with a Frand rate of 61 cents, which is the correct rate to be comparing at this point, because we're dealing at this point in just what rates can be extracted from the licenses. But is also inconsistent even with the rate for which my learned friend contends as the ultimate Frand rate after adjustment. And indeed the position is actually, as it happens, worse if one uses the Norwich City graph, because the rate for Apple in that graph is even lower.
I haven't understood why that figure is low. Where does that figure come from?
As I said that, I knew I would be asked that question.
Norwich City.
Yes.
That's because they've had the adjustments, so they're all on the Lenovo mix.
Oh, I see.
And
yes.
What my friend's been showing you are just unpacking out, trying to do that.
Yes. Thank you.
Well, my lord, whichever number one is using, the fully unadjusted rate for comparison, the adjusted rate, this finding
it applies across the board.
Can't be reconciled with my own friend's rate case. It just cannot.
Can I go back to another point you made about Apple? You said it's a future-only rate.
Yes.
Well, we know that's what Mr. Mellor has done. He's taken the quantum of assumed future sale as the, whatever it is, denominator, and the quantum of assumed future payment as the numerator, or the other way around. But it's not a license that was actually priced as a future-only license, and the split between the past consideration and the future consideration, as my lord said, is based on the Form 10K. So if that split is not something you can rely on, then that also distorts the figures, doesn't it?
Well, my lord, and that may be why, or an illustration of why using this rate as an upper bound is, if anything, generous, because the rate that one sees at 6581, to the extent that there is an inflating effect of using the 10K split, which one can fairly clearly see from.
I'm sorry to interrupt you when you're in mid-sentence, but yeah, I would jib at the suggestion that that's what Mr. Meyer was doing, because as I pointed out earlier with reference to 657, he tried to tackle the problem in a different way, which is he couldn't do the unpacking of past versus future in the way that he did for some of the other licenses. But the reason for that, as we discussed earlier, was because of the unreliability of the unit figure. But nevertheless, he did allow for the amount of consideration that was recorded in the 10K as attributable to the past. He dealt with that in a different way. So although it's described as a future-only rate, and in a sense it is a future-only rate, it's a future-only rate in a very specific and unique sense.
I would not disagree with that, because in this particular instance, what it does not produce, because of the particular nature of the analysis being undertaken, is a corollary past rate with which it can then be presented in the way that Mr Meyer always sought to do with other licenses where he could produce those two rates. So one can't see the relationship between the two in the way that one can see it with other licenses. So I agree with my lord's observation to that extent. It remains the case, however, agreeing with the point made by my Lord Justice Nugee, that the split in consideration in determining this was the rate taken from the 10K, because that was, as we know, what Mr Meyer used across the board as his proxy. But if it is right to come
my
back
understanding
to,
is part of your case is the 10K split, which is a way of presenting the lump sum by attributing heavy discounting to the past sale. It's not actually an accurate way of getting at the figure.
well, that is certainly what the judge found. He was more than entitled to find that. And our case as to the way to address all of this always was and remains that the best way to examine these licenses is simply to examine the total consideration divided by the total number of units. It's what's done in the industry, it's what Mr Meyer recommended, and unless there is some basis for inferring that the lump sums were depressed to some quantifiable extent below the Frand rate, which on the evidence there simply isn't, then the correct way to approach this is simply the blended analysis. And that must be a fortiori for those licenses where there were no past sales at all.
Yes, but as we've seen, Apple isn't actually one of them.
I see that. It's a sort of
It's not a
intermediate
future-only
position.
rate in the way that Samsung is a future-only rate. But the difficulty with that is the bits in the judgment which say there is this practice of heavy discounting for the past, which don't. I mean, I think we might need to look at those again, but they don't read as if the judge is simply saying this is how people present it, but actually what's going on is you're agreeing to pay the same rate throughout. They read as if the judge thinks that people in the market actually do perceive there to be a real problem with recovering past rates, and so do discount.
Well, my lord evidently has that first point that we make about the fact that past sales are often used as a basis, a rationale in negotiations to justify move on the lump sum. My lord also has the point that the proof of the pudding, in a sense, is those licenses where there were no past sales. They're the control test. But a further layer in that regard, and it's the third of my 8 points which I'll be coming to, is that ultimately, even if those first 2 points fail, the question then was, let us assume that the judge's finding implies that to some unknown extent, there is a depression in the lump sums concluded for those licenses where there were past releases. The question is, was the judge offered any reliable way of accounting for that, which did not lead to a rate which he based on all his evaluation of the facts, considered to be inflated? And the answer to that is no, because the only way he was offered of dealing with this, perhaps because the point arose only in the context of an unpleaded fallback case developed halfway through the trial, was that he should simply ignore past sales altogether, which leads to you using a future-only rate, which the judge was more than entitled on all of the evidence in my submission to conclude was inflated, and he did include was inflated.
Doesn't that cut both ways? I mean, you criticise your opponents for not stepping into the middle ground and saying, well, okay, if this isn't a scoop the pool argument, you haven't told us how far it goes. Well, that applies to you as well, doesn't it? If the conclusion is that this means that the rate that the judge reached is wrong and it needs to go up, the only place we can go is Mr. Speck. You say, if Mr. Speck succeeds in convincing us that the rate is one that should move down, you see what I mean? I'm not.
I do. I obviously.
What I'm concerned about is that you're both, in that sense, running the same bit of advocacy, because nobody wants to step into the middle ground in case anchoring takes place.
Well, my lord may be right about that. The ultimately, as my lord knows, our case was all these discounts are just ex post facto rationalisations of market values reached in licensing negotiations. It was my learned friend who had a case developed halfway through the trial. The best thing to use was LG 2017, and let's just use the future-only rate. So insofar as anybody should have been putting forward some kind of way of quantifying this apparent effect, it would have been for InterDigital, and they didn't for obvious forensic reasons. And indeed, no doubt the fact that it arose so late.
Yeah. We're conscious of the fact that we've interrupted you quite a lot. And you have answered our questions, which have sometimes been repeated very patiently, for which we're grateful. But since we're nearly at the end of the day, can I just ask, are there any points on the remaining licenses in the Lenovo 07 that you've got that aren't just repeating what you've already said? Because obviously, we have read all of this, and you've been helpful in highlighting particular points by reference to, e.g., Samsung and Apple and Huawei 2016, which I think has been helpful. But do we need to go into the same level of detail with regard to, say, ZTE 2019? I mean, you've drawn out some technical points about that already, but do we need to go into the same level of detail?
Well, my lord, probably not. For LG 2017, the point I would obviously emphasise is the finding that the future-only rates were inflated.
Yeah.
That's paragraphs 618 to 620, 721, and 882. In relation to ZTE 2019, the judge's expression was probably on the low side, and on the low side. That's paragraph 684 to 687 and 798. That was not particularly reliable, paragraph 805. But in any event, probably on the low side, again, would not begin to encapsulate the divergence if the true Fran rate were 49 or 61. Huawei 2020, the judge found that both parties were satisfied with that. That's paragraph 696. And Xiaomi 2021, the judge found there was no support for the suggestion of a lower rate. That's paragraph 708 to 710. And that in any event, lower rates were consistent with the gradual decrease of rates over time. That's paragraph 798 to 799. So for each licence, the judge examined whether there was evidence that the lump sums had been substantially depressed below the Fran rate, and generally concluded that they had not been. For certain licences, he recorded that the rates were slightly low or somewhat low or such like. Others were a counterbalance to that, and one was an upper bound only. But as I'll be coming to tomorrow, we say those findings are not reconcilable with the idea that lump sums were all massively below a FRAND rate. That's not the end of this point, but I think that's probably a convenient moment.
Very good. As I've just said, you've had a lot of interruptions, which I must apologise on behalf of the court. But how are you doing time-wise?
Michael's somewhat behind where I wanted to be, I will confess. It's obviously, ultimately, I want to answer the court's questions if I possibly can. I shall do my best to speed up tomorrow.
Very good. Thank you.